everyone. Welcome to season 4, episode 4 of ARBinBRIEF, a practical video guide on handpicked arbitration issues. My name is Alessa Pang, and I'm part of the ARBinBRIEF team, and I practice international arbitration with Wong Partnership in Singapore. I will be moderating today's episode on inequality of arms in arbitration, featuring Philippa Charles, a full-time arbitrator at 20 Essex in London, and Saemee Kim, a partner of the international arbitration team at 𝗔𝗥𝗕𝗙𝗥 in Seoul. Links to their profiles can be accessed in the chat box. Now, moving straight into the topic, the notion of equality of arms in arbitration is often equated with fairness, which is fundamental to natural justice. And in today's episode, we discuss the ways in which an inequality of arms may arise in arbitration proceedings, both in commercial and investor-state disputes, how this could result in due process complaints, and what arbitrators can do to mitigate the risk of such complaints. We will then end off by discussing tools which may well equalize the playing field, thereby minimizing concerns of issues arising in international proceedings. Now, as arbitration clauses become more commonplace, even in consumer contracts, it's not uncommon to find yourself in a situation as an arbitrator where a party may not be represented. National courts are used to this, but what happens in arbitration? And maybe Saemee can share her experience in having dealt with such a situation before.
Yeah, thank you, Alessa. So in my experience as an arbitrator, I encountered a situation where an underrepresented party directly called me to discuss the case. It was not even an individual party in a consumer arbitration, but a dispute between two small to medium-sized companies. One represented by counsel, the other unrepresented. So when he called me, it became apparent that he was unaware that ex parte communication was not allowed in arbitration. So I explained to him that I could not engage in such discussions, clarifying that my role as an arbitrator required impartiality and that all communications needed to include both parties to ensure fairness. However, the same party called me one or two more times, and I realized at that time the situation required a more structured approach. So I promptly notified the arbitral institution and asked the case manager to contact that party and provide guidance on how to communicate in arbitration. The institution stepped in and emphasized that all inquiries should be through email, copying everyone. After that, that party did communicate through email, but he would send the email only to me without copying anyone else. So I had to copy everyone when replying to his email and remind him of what proper communication would be in arbitration. So this experience underscored for me the challenges unrepresented parties can pose in arbitration, not out of malice, but often due to a lack of understanding and experience. So we can think about the delicate balance arbitrators must strike when dealing with unrepresented parties. On one hand, we must remain impartial and avoid providing procedural advice that could favor one side. On the other, we have a duty to ensure procedural fairness and maintain the integrity of the arbitration process. So in this case, involving the arbitral institution allow me to maintain that balance and ensure both fairness and compliance with the rules.
Thanks, Amy. Yes, it can be particularly tricky because I think we take it for granted when you often deal with counsel represented parties.
Right.
So I'm just interested to also explore how, this issue of inequality could arise in the context of ISDS, especially where state parties are involved. And maybe Philippa can share her views on this.
Thank you, Alessa. Yes, I think there's a general concern both amongst commercial parties and indeed state parties as to the costs of representation in international arbitration matters. And I think it's realistic to assume that a party in ISDS will be represented by specialist counsel. But for states in particular who are dealing with taxpayers' money, they are under pressure to limit their costs exposure, and you generally find that they will have very strict budgets in relation to their representation. But that's not always apparent from the tribunal side. And there's a recent example in the UK in the case of PNID and Nigeria, which has drawn attention for various reasons, including how valuable the award was against Nigeria and the circumstances in which the awards were subsequently set aside for fraud. But one aspect which came out, I think, on the challenge proceedings was the fact that Nigeria, throughout the arbitration process, had had difficulty retaining counsel, paying counsel, giving timely instructions, and providing funds, for example, for the retainer of a damages expert. And the impression that was formed, I think, certainly on the tribunal, was a negative one as far as Nigeria's position was concerned. And because Nigeria had already lost on liability, I think the difficulties that they experienced because of these sort of cash constraints had an impact, I think, on the way in which the tribunal approached the damages phase. And certainly the judge in the challenge proceeding seemed to feel that the tribunal should have been more understanding of the position of the state in those circumstances. So it's worth noting just generally that the ICC, for example, has published specific guidance for tribunals on the management of cases involving states or state-owned entities, which highlights the need for the tribunal to be sensitive to the fact that a state may need additional time to give instructions or to retain counsel. And in any case, I think where a party is not represented at the outset, it's right for tribunals to consider what sort of accommodations need to be made to allow that party to obtain advice and representation within a reasonable timeframe. And where a party is changing advisors during the process, it's right for the tribunal to be conscious that that might represent actually a situation of financial pressure more so than a difficulty with the substance of the case. And it's understandable that a party won't want to publicize the fact that it's having these difficulties, but I think it's incumbent on tribunals to bear in mind that there may be more than one reason for these issues to arise.
Thanks, Philippa. Yes, it can be particularly tricky, especially sometimes particularly in arbitrations in dealing with state parties sometimes. I mean, we've talked so far about all the problems that could arise in both commercial and ISDS disputes. And hopefully it's not all doom and gloom, and one wonders if there are tools available which could help equalize or level a playing field so that arbitration doesn't seem so inaccessible as a form of ADR. And so what are some of these tools that counsel or parties can consider? Maybe Philippa, you could just share a bit on this.
Sure, thank you. Thanks, Alessa. I think there are four things I would point to. One is that in certain jurisdictions, it is permissible for lawyers to risk share with their clients, and that can be a tool to enable a party to minimize its immediate exposure to costs pending the outcome. Another option is third-party funding, which now has been validated in many jurisdictions. And that, I think, can provide access to dispute resolution processes which would otherwise be unaffordable for a party. It can be expensive because the third-party funder will recover a portion of the recoveries in addition to the amounts that it's actually invested in the case. But there are, I think, advantages to involving a funder which go beyond simply the payment of the day-to-day costs, including the use of second opinions to validate the party's legal position and the potential perhaps for earlier settlement of the case. There are two other matters which I think come up as procedural management tools. One is the incorporation into the first procedural order of identified soft law instruments, which can provide a common approach to the tasks to be undertaken. And I think particularly with respect to the treatment of evidence, both disclosure and witness and expert evidence. And that provides a reference point for all parties and the tribunal so that there's a common set of expectations about how the practice will work. And it allows the tribunal in a way to provide guidance without appearing to be intervening in the way in which the party is represented. And the second thing I tend to try to do is to produce a very detailed procedural order number 1 and to discuss specifically with the parties what is in that very detailed procedural order number 1 at the first procedural meeting, because in that way it enables the tribunal to assess the confidence and the competence of the representation, and again also to level the playing field in terms of what the expectations are across both the parties and the tribunal.
Thanks, Philippa. I think a lot of important points were raised, especially in relation to procedural matters, because as we all know, a lot of challenges to awards tend to turn on procedural issues or that occur in the course of arbitration. And I think in the course of our discussions leading up to this episode, Saemee brought up interesting view, which is about how AI can be used. So much has been said about AI, and I thought be helpful for Saemee to share her views on how AI can be harnessed as a tool by parties to level the playing field.
Mm-hmm. Thank you, Alessa. I think many factors contribute to inequality in arbitration, whether a party is represented, whether their counsel is from a well-sourced firm, or whether the lawyer is experienced in arbitration. All these elements can create disparities. AI is often highlighted as a tool to help level the playing field in arbitration. Just to introduce some of the features of AI. I'm pretty sure everyone will be familiar with these, but so I won't go into detail. So there's some legal research tools that can bridge the knowledge gap. Platforms provide streamlined access to legal case law, procedural guidelines, and legal principles. Unrepresented parties or lawyers from smaller firms can have access to various arbitration-related information and participate more effectively. AI-based case management systems also promotes procedural fairness. These systems ensure that deadlines, filings, and procedural requirements are communicated clearly. So for those unfamiliar with arbitration process, automated tools can guide them through the process, making it less daunting. AI-driven language translation tools also lower barriers in international arbitration by providing accurate and low-cost translations these days. And additionally, AI-based evidence review tools can analyze complex data sets or identify anomalies in documents submitted by the well-sourced parties. So this will empower the under-resourced parties to engage with the evidence on a more equal footing. So these features hold promise, but I'll have to say that there are challenges. So first, cost. Cost remains a major hurdle. As many AI tools that are, they are not that cheap, and may feel burdensome for smaller firms or unrepresented parties to adopt AI tools for a single case. And there's also a risk of AI misuse or over-reliance. Utilizing AI requires careful calibration to ensure that AI doesn't inadvertently reinforce biases or create hallucination. So quality control is critical when using AI. Um, if you if there's a misuse of AI, I would say that it could exacerbate inequalities in some sense. And larger firms with more resources can afford to supervise AI outputs without heavily relying on them. Whereas under-resourced parties may not have attorneys or resources to review and confirm all the outputs. So, and I also heard that big law firms can even develop proprietary models tailored to their clients' needs, giving them a further competitive advantage. So, to some extent, it doesn't help equalizing the inequality, but I guess ultimately the impact of AI on inequality will depend on its accessibility, affordability, and ethical use.
Thank you very much, Saemee. So I suppose the conclusion is that AI could help to a certain extent with sufficient overwatching controls, but ultimately, as with all things, it would depend, and too much of something may not be a good thing. So thank you very much. And we've come to the end of the episode. Thank you very much, Philippa and Saemee, for this very insightful discussion. I'd like to thank our partner organizations, ERBpledge and the AAA ICDR Asia Case Management Center for the support in making season 4 possible. For those who are watching us over YouTube, our video ends here. Thank you for joining us. And to see future ARBinBRIEF videos on handpicked arbitration issues, please follow us on LinkedIn and subscribe to our channel on YouTube. We'd like to hear your feedback, and you can register for our next episode at arbinbrief.com.